Marshall Chriswell is with us, and this radio program is intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. I know one of those. It's Marshall Chriswell. Good morning.
Good morning.
How are you?
I'm doing well. All things considered with the snow.
Yeah. Well, there are many things, many directions in which we could go this morning. There are new taxes and tax laws that people are thinking about in terms of their estates. There are obviously other legal issues out there in your world. What are some of the things that you are concerned about lately?
Well, something that's come up, several times in my practice recently is a question. We've talked that, a big part of my practice is handling probate estates. Mm-hmm. So when someone passes away, generally what that consists of is, meeting with a person who's going to be appointed as an executor or administrator of the estate, getting them sworn in to be in that role and assisting them with the administration process, making sure they do everything according to law. Things like taxes are paid and debts are paid and distributions are made to the beneficiaries of the estate, consistent with the law or consistent with what the will or trust or final documents of the deceased person were. So that that's the normal course of things. But something that's been coming up more recently, and I think it probably bears a little bit of a discussion because maybe people don't understand some of the different roles and things here. If you are the beneficiary of an estate, mm-hmm. okay, or you think you may be the beneficiary of an estate, and things are not progressing with that estate as maybe you think they should, or you're confused about why things are being handled the way that they are by the executor or the attorney for the estate, what do you do in that situation? Because as I said, regarding roles, sometimes there's confusion. The attorney for the estate represents the executor or the administrator. And so, as a beneficiary, you can sometimes feel like you're not getting enough information or you just don't know what's going on. So it's important that you contact your own attorney. After maybe taking a chance to taking an opportunity to talk to the executor or the administrator and their attorney and saying, okay, hey, what's going on here? If you're not getting satisfactory responses or you're still confused about what's going on, you have every right as a beneficiary of an estate to consult with your own attorney, mm-hmm. And say, okay, what are the rules here? What are they? What should really be happening? And get some advice that way.
Okay, you can get advice that way. You can't force the process to move any quicker, though, because you're not directly involved in it, correct? No,
you can, and that's where some of the confusion lies. Now, estates, and it's a source of frustration for executors and beneficiaries alike, that sometimes estates move more slowly than we would like, for lots of reasons. The process is designed to be deliberate so that we ensure that creditors are paid properly and everything is wound up correctly before making distributions to beneficiaries. But as a beneficiary, you do have some legal power, as set forth in our statutes. Number one, and this happens sometimes, you have someone who's responsible for an estate, someone who's appointed as an executor, or someone who is a next of kin, a spouse or a child, who should be opening an estate, should be probating a will, who isn't doing it, who's mm-hmm. just sitting on it for whatever reason. And sometimes it's not always nefarious. Sometimes it's, they're going through a grieving process, sure. and they're not, and they're just not dealing with it, or they're not sure what to do, or they think they don't have the money to do what they need to do, or whatever it is. But as a beneficiary, there's a process you can undertake where you file a petition for the production of a will. You file a petition with the court and say, all right, this person is, I believe this person is in possession of a will that should be probated, and the court will do what they call is they issue a citation, not like a speeding ticket citation, but it's a legal term for a notice to that person that says, hey, if you have this will, you need to bring it in and probate it. So you can move things forward that way.
Is there a timeliness clock or calendar that kicks in at any point?
The law says that a will can be probated at any time.
Okay. So
I've had folks call me that say, "Hey, my uncle passed away 20 years ago, and an estate was never opened. I have the will. What do we do? We can move. Yeah. So there's no deadline on when to do these things. There's the process to force the production and probating of a will. Also, once the administrator or executor has been appointed, there are things that you can do to get information. You can file a petition for an accounting of the estate. You can request to know what the assets and debts are of the estate. There are things that you can do and information that you can get by law. And again, sometimes the process is just going to move slowly. Really the executor, the attorney for the estate, should be sharing some information with you because the executor has what's known as a fiduciary duty to the beneficiaries of the estate, which is really the highest legal obligation that we put on someone with regard to their obligation to another person. Same thing if you serve as power of attorney for somebody, you have a fiduciary responsibility, a fiduciary obligation to do what's in their best interest. Same thing with an executor and beneficiary relationship. You've got to be doing what's in the beneficiary's best interest, not your own, even if you are a beneficiary. In addition to being executor. So it's. The roles is kind of what folks don't understand, and you just wouldn't unless you've studied the law. As a beneficiary of an estate, or if you think you are, and you can't get the information you need, or you think that something's going on that shouldn't be, I'd urge people to set up a consultation with their own attorney.
Absolutely. All right. But of course, there are many things that you can do before you get to that stage, before someone even passes away, that would help forestall any of these difficulties and these timeline types of things.
Sure.
And obviously, nobody knows when their time is going to come. But we know that in any given time, we can certainly make the sorts of arrangements and bring everybody in on the process so that everybody knows what's going on, and an attorney can be involved in that as well.
Yeah, and that's something we've discussed before, right? Whenever it's obviously a great idea for anybody, no matter what your estate may look like, big, small. It's important to have that estate plan in place. And not only to put the documents in place, but also the folks that you're appointing in those documents as powers of attorney, medical agents, executors, trustees. You really want to have a conversation with those people. You want to make sure, number one, that they're the right people for the job, that they want to serve in that capacity or they would agree to. And also you want to think about what particular skill set do these people have, and does it lend itself to performing these functions? You're not going to appoint somebody as your power of attorney or as the executor of your estate if they have shown that they can't handle their own finances. Somebody that can't balance a checkbook, somebody that is constantly, your cousin who's filed bankruptcy 3 times. You're not going to appoint that person or you shouldn't. Also, you want to think about family relationships. Do you want to put in place an executor who doesn't get along with anybody else in the family? Maybe you do, but you at least want to have a conversation about it and think about, all right, is that going to be the most conducive, create the most conducive environment to getting things wrapped up and resolved in a timely manner, and so that there aren't disputes.
Yeah, and it probably is a really good idea as well for somebody who has been informed by their parents or by somebody else, you're going to be the executor of my estate, for them to come to the attorney and say, okay, what does this mean when the time comes and I'm called upon to do these duties? what are my obligations? How do I proceed? If you could have that lined up ahead of time, that would be great too.
Yeah, absolutely.
That happen?
Sure, to have a discussion between an attorney and an exec. Yeah, absolutely. I will if someone has questions about, okay, what are my responsibilities going to be serving as a power of attorney or as an executor when the time comes, I urge them to sit in on part of a meeting. When the person who's creating a will or a trust comes in to review and sign those documents, bring your son or daughter or whoever's going to be serving in these roles. And for at least part of that meeting, because some of it will be confidential probably, but for at least part of that meeting, have them sit in and we can discuss what your expectations are for them and also what the legal requirements are.
We in the past have talked as well about people who are no longer capable of making decisions, and they don't have their arrangements made in that respect, and that can be a very, very complicated thing. And the attorneys are going to be the point men, point women in that respect as well.
It causes all kinds of problems, Todd. All kinds of problems. We are in a situation. As a society, obviously, people live a very long time now, life expectancies, and almost all of us, or the majority of us, are going to go through a period of time, and how long is it? It's different for all of us, but a period of time where you are unable to make decisions for yourself, usually towards the end of your life. And if you haven't taken the steps to have a power of attorney in place, and make those arrangements, you can be presented with a situation where your entire family's hands are tied. They need to sell assets to pay for your care because the assets are there, and the state isn't going to kick in and provide assistance to you to pay for nursing home care or what it may be when you have assets that are sitting there that could be used, but they can't be accessed. The house can't be sold. The bank accounts can't be liquidated. The investment accounts can't be liquidated because nobody has the legal authority to do it but you, and now you are incapacitated and unable to sign a document. So now we're forced to file a petition with the court, have a doctor testify that you're incompetent, have a judge make a decision, and importantly, a judge is going to make a decision about who now is going to be put in place to serve as your guardian and make all those financial decisions. And it may not be the person that you would have intended.
Yeah.
So it's really that part of the planning process is really becoming, in my mind, almost the most important.
It is fraught with emotion too.
Yeah.
And that it really becomes difficult. Well, if somebody wants to know more and start the process in motion here, what do they need to do?
You can contact my office. We're here in the Atrium Building in downtown Indiana. Phone number is 465-5826. And you can always go online to www.westernpalawyer.com.
Thanks, sir.
Thanks, Todd. Have a good day.